behalf of the plaintiff MCD, we have a response and motion on file in connection with our response.
Jennifer
Okay.
Covington. Oh, sorry, Your Honor.
Go ahead.
Jennifer Covington on behalf of Linda Lunn and MCD. Oh, excuse me, and Keller Williams. Apologize.
It's okay. So are you guys going to want a record on this?
No, Your Honor.
Plaintiff does not need a record.
And we're going to be on YouTube in case anyone needs to look at this again. So we're here on a motion for leave. Why don't we go ahead and proceed?
Thank you. Well, our motion is unopposed. It's to grant defendants Westdale and its related entities, the JGB entities, an opportunity to give us 30 days from the date that plaintiff amends its disclosures indicating what its damages are and the method and its damage calculation. So to allow us time to designate an expert once plaintiff has done that. And we've submitted an order and it's unopposed, so we request that it be granted.
Okay, let me see if I can find the order. Okay, I think I see it.
And Your Honor, this is plaintiff MCD. It's unopposed if that is part of a broader modified discovery control plan in connection with this case. There is a disagreement among different groups of defendants as to what the status is of discovery in this case, as set forth in my response. Some of the defendants, I call them the seller defendants, it's Westdale, Ms. Fry's client, and their affiliates filed a plea and abatement in connection with this case when this case was filed. And they asserted that discovery should not progress in this case until such time as a mediation has occurred based upon the earnest money contract between my client and their client. Back in December, Mr. Needenpure wanted to take the deposition of one of the co-defendants who's no longer in this case. And we entered into a Rule 11 agreement with Ms. Fry's client at that time that we would not claim that allowing that deposition to go forward would in any way waive their right to insist that mediation should be conducted before discovery. And we at that time talked about even alternate mediators besides the one the court had appointed and dates, etc. We were not finally able to have that mediation until July 5th of this year. And shortly after that, the parties filed a joint motion to continue the trial setting because obviously mediation had occurred so late. And there had been no depositions at all except for the one deposition that we agreed could go forward despite the claim that no discovery should be conducted due to the abatement. So we have no objection to extending the time for Westdale or any parties to designate expert witnesses and believe that a modified discovery control plan should be entered in this case based upon the fact that obviously we did not oppose the abatement sought by Ms. Fry's client and tacitly agreed to that. The court didn't enter a formal ruling or anything. And we've submitted a proposed modified discovery control plan with blanks for the court to fill in connection with our motion.
Response, I'm not sure I fully understood that, but response.
Yeah, I wasn't aware that the motion was unopposed on a condition, so that's news to me. But our position is that discovery is open. There's no reason for a modified discovery control plan. It's not set for hearing right now, so we request at a minimum that the plaintiff's motion be set for hearing to give all of the defendants an opportunity to respond. I believe as to Westdale, discovery is open till January 7th, is my understanding, 30 days before trial, and we're proceeding on that basis and we're prepared for the trial date. So we don't have any reason to modify anything. But we request at a minimum that the plaintiff set his motion for hearing so that we can respond.
Your Honor, on behalf of the condominium association through management companies, may I respond?
Okay.
Your Honor, MCD in its response also asserted this motion to basically reopen discovery and enter this discovery control plan. Their motion, MCD's motion, is not set for hearing. So I would echo Ms. Fry's sentiment that we would like the opportunity to have that formally set and respond. But just by way of information, my clients did not approve of any abatement or any sort of suspension of discovery. This case has been proceeding with respect to my clients under level 2. And as a result of the discovery that has taken place, some written, the one deposition, the discovery period ended back in August. And that's our client's position. So the means to getting to the same end as Ms. Fry is, we do believe, for our clients at least, maybe not for the Westdale entity, that discovery has closed and would oppose reopening discovery and entering into a docket control plan.
Okay, so it sounds like I never signed an abatement on this, correct?
Correct,
Right.
Your Honor. And the discussions between MCD, the plaintiff, and Westdale regarding any sort of abatement was just between those two parties based on their contractual relationship. It had nothing to do with the other defendants. And so all the other defendants, it's my position, Your Honor, are proceeding under level 2, again, which had expired back in August.
Yes, Your Honor, and Westdale doesn't take any position as to the other defendants. We're solely saying that discovery, as for us, is open because it didn't begin until mediation. That was a condition precedent. So we're actively in discovery. I've subpoenaed records. We're prepared as soon as I receive those in the next week, I believe. Then we're ready to take the plaintiff's deposition, and we're continuing under the rules of discovery.
Your Honor, that's exactly why MCD has filed what it's filed in this case. Some of the defendants are taking the position that discovery is over, and Ms. Fry and, of course, MCD believe that it is not. If MCD is going to be deposed by Westdale, I'm assuming Mr. Niedenfuhr and Mr. Miller are going to participate and want to question my client in connection with that deposition. But at the same time, Mr. Niedenfuhr and his clients are taking the position that we can't depose any of their representatives because for them, King's X, we were able to delay mediation until July 5th. And so you can't do any discovery of us, but through Ms. Fry, we can do whatever discovery we want against you.
So let me ask this to the plaintiff's counsel. So it doesn't sound like there's any agreement to extend any type of discovery. Are you opposing this? I mean, and it's not
If
set
discovery is over,
wait,
yes.
wait. Let me finish what I'm saying, okay? Well, my question is, are you still not opposed to granting leave to allow this defendant to designate an additional expert? Or, I mean, because there isn't an agreement. So you seem to have taken the position, and I'm not fussing at you for this, that that you only will agree to this extension if there's an extension of everything else. No one seems to agree to that. And so are you still not opposing this relief?
No, I do oppose this relief if there will not be a modified discovery control.
Okay.
I oppose defendant getting an extension of time to designate an expert if discovery is closed, as Mr. Niedenfuhr's client argues.
Okay. Well, discovery seems to be closed, so it seems like you're opposed to this, and unless there's some agreement you guys can reach. Maybe we should punt this and give you a chance to try to work this out with the other parties and set this other motion for hearing.
If you need another hearing date, I would be happy to set this for hearing.
I don't need another hearing. Well, I don't need another hearing date. This just isn't set this hearing date. So if you don't think this is the court driven, this is me simply reacting to you saying that there needs to be an extension, everybody opposing it, and it not being set for hearing today.
Your Honor,
Nobody seems to be agreeing that this should be heard today.
No, Your Honor, our motion, I believe, should be heard today. I believe it should be granted. The plaintiff sold this property, or it was foreclosed on, in September 7th. We have asked them several times to amend their disclosures to give us some indication of what their damages are. And we've received no response. It's now months later. This is now prejudicing our position. We cannot name an expert until we know what their damages are. And so we're asking for the motion to be granted, regardless of what plaintiff does down the road. That is not, I don't believe that's contingent upon this ruling today, or vice versa. So we're requesting that the order be entered as is, and then if plaintiff wants to set his motion, that's fine. But I think we should not be prejudiced by the fact that the plaintiff hasn't been diligent in discovery and updating its responses as required by the rules.
And just to be clear, Your Honor, none of the other defendants oppose Ms. Fry's motion for this limited extension of time.
That's correct, Your Honor. My clients, the Redmonds, do not oppose this extension. It is needed. I agree with Ms. Fry that
this particular extension.
yes, Your Honor. The extension.
But you oppose all the other extensions.
Discovery is closed, Your Honor, and the plaintiffs didn't work the case very hard, and discovery is closed. There's been no agreement otherwise. Now, I understand Ms. Fry's client has a contractual argument regarding discovery, but as for the rest of us, discovery is closed.
Mr. Frick?
Your Honor, quite frankly, maybe we do need to reset the hearing, and I'll set my motion for hearing at that time. But I do oppose Ms. Fry's request. The property was foreclosed on twice, once in September and once in October. We still do not have the information from the parties that foreclosed as to what the bids were, how much money in excess of what was owed was paid by the two purchasers, and how they're reconciling the COA. Mr. Niedenfuhr's client foreclosed first, and the purchase money lender foreclosed a month later because the purchaser didn't pay the purchase money loan off. So we don't have the dollar figures to calculate our exact damages. I agree with Ms. Fry on that respect. That's one of the reasons why this discovery control plan needs to be pushed back. Now, with respect to you did not rule on the abatement. Perhaps we should have gone ahead and had a hearing on the abatement, even though I was in tacit agreement with Ms. Fry. My argument was, hey, the court already entered a mediation order. Let's mediate. Her client's complaint was, we wanted to do an early mediation before we did discovery. It's not my fault that we couldn't get the other defendants all on board with dates. It's not my fault we couldn't get the mediator on board with dates because of COVID. So we did agree to take one deposition. That's the only deposition that's been taken in this case. If the defendants are going to assert, if some of the defendants are going to assert discovery is closed, it closed back on August before either foreclosure sale, then let's go with that. But I think that's wrong. I think that's not in the interest of justice, and I think that's not appropriate.
Your Honor, if I could just make one more comment. I did reach out to Mr. Frick in September. I believe it was September 1st. And I said, hey, why don't we talk about a scheduling order? And I never heard back from him. So we have moved forward in the absence of any response from Mr. Frick, and we're complying with all the rules. We're doing our discovery, and we don't believe that we should be harmed by his inaction. Our motion is set for hearing for today. We request a ruling. Plaintiff can set his motion, and you can decide that at that time, and that's our position.
Your Honor, I just want to be clear on this this topic of mediation. Any discussions between Westdale and MCD regarding mediation, those were separate. As to my client, and I believe the rest of the defendants, MCD did not come to us early on in this case saying, hey, let's go to mediation. The minute MCD did come to us about mediation, I believe it was June, and we immediately all responded with dates and scheduled and attended mediation in July. So we did timely respond to MCD's request to mediate. Notwithstanding that fact, some of the parties, including my clients, were in considerable discussions with MCD in attempting to try to resolve the case early on informally. So I just want to make sure that the court is aware of those facts.
All right, so let me just say this. So I'm going to grant the motion that's set for today.
Thank you, Your Honor.
I'm not going to rule on this other motion because it wasn't said. I will say this, that, you know, during COVID, I've always been pretty liberal at granting continuances when there's basis to do so. And I'm all likelihood I would extend the deadlines to allow additional discovery to occur. That's not a ruling today, but in all likelihood, that's what I would do, just FYI. You can fight about it and bring it before me, but just given the age of the case and the backlog that we all have because of COVID, in all likelihood, I would extend the deadlines, but I'm not going to. I agree with Mr. Miller and the other defendants that it's not set for today. I'm just kind of giving you a preview of how I generally approach this. So maybe you guys could avoid a hearing and come up with some type of agreement you can all agree to. But that being said, Ms. Fry, if you could submit a new order on this. I looked at the order on this. If you could say at the beginning of the order that it was heard on November 22nd, 2021, instead of on this date. And then at the end of the order, if you could include a sentence that says something like, this extension is without prejudice for the parties to request additional extensions to discovery. The court is not ruling on that at this time, or something like that. Just
Thank
to
you,
make
Your
sure
Honor.
that I'm not ruling one way or the other on any other extensions of time.
I will submit that order.
And then if you could go ahead and email that to my court coordinator, Rhonda, as well as e-filing it.
Your Honor, I have a question, and you may not be able to speak to this, but this matter is set for a jury trial in February of 2022. I believe it was filed in September 2020. And you may not be able to answer this, but what do you think would be the likelihood that we might be reached? And I realize that's a few months out.
Very low. I mean, it's possible, but very low. The good news is that we're starting to try. I've been trying cases. A lot of other judges have been trying cases. I've tried about 8 or 9 since the pandemic, which would be a very low number usually at this point in the year, but I think it's pretty good given how things have been going. Starting after Thanksgiving, assuming nothing changes, the current rule is, or current instruction that I've gotten from our local administrative district judge is that we're going to be able to pick juries in our courtroom. There's still going to be a limited number of juries each day until the end of the year. And then at least as of this time, starting in January, we're going to be going back pretty much to normal, with the exception, I think, that folks are going to have to wear a mask. And what I mean by normal is the people are going to be summoned. Normal number of jurors will be summoned. Judges can get jury panels whenever they want, like we did before, or not whenever we want, but like we did before. And so how that dynamic is going to work with this case, it means that I would have said there's no chance, but there is some chance that you would go to trial. I will say that, just because we're starting up, assuming nothing changes with COVID again, we're starting up and trying cases again. But this case is still relatively new. And so the chances are not 0, but probably not 50% either.
Thank
Does
you.
that help?
Yes, thank you. Thank you.
Did anyone else have any questions?
Your Honor.
Okay, well, just go ahead, Mr. Frick, set that other motion at your convenience. Ms. Fry, go ahead and get another order in for me. And the rest of you guys, or everybody, have a great Thanksgiving, okay?
Thank you so
You too.
much.
Thank
You
you.
guys.
Thank you, Your Honor.
Bye-bye.